Hello, everybody. The case I decided for this week is Case Study 7.1 Blair versus Washington State University. This can be found on Chapter 7, page 187 in our textbook. So, this case is a sex discrimination case that is brought on by Washington State female athletes and their coaches. So, I found this case to be very interesting. It kind of reminds me a few years ago, a viral TikTok during the NCAA tournament. A woman's college basketball player from Oregon posted a video showing the NCAA men's workout room versus the women's workout room, and you could see in the video that the men's weight room was far superior to the women's. Had a lot more stuff, had a lot more room, and same way with the practice facilities overall. And she was letting the NCAA know her thoughts on it and how that wasn't fair, and that they needed, they deserved to have the same options as the men had in their weight room. They deserve to have just as good as weight room that is comparable to the men's, but they didn't. But anyways, so this case kind of get where this case is going. So in this case, the plaintiffs are the female athletes and their coaches. They sought to review and a decision by the Superior Court of Whitman County in Washington, which excluded football from its calculations. I'll get to more on that in a minute. Excluded sports-generated revenue from university financial support and eliminated a year's worth of damages because tort action was conditioned precedent to discrimination suit. Respondent university sought review of the attorney fee and cost rewards. So, facts of the case: the plaintiff, female athletes and their coaches, filed a discrimination suit against the respondent, the university, for inequities in the amount of funds available to the plaintiff, and the trial court entered an injunction. So this was kind of the discussion in the court. The court held that the football team should have not have been excluded from the trial court's calculation for participation opportunities, scholarships, and distribution of non-revenue funds because the Equal Rights Amendment and laws against discrimination prohibit such exclusion. The court affirmed the decision that each sport would be allowed to keep the revenue it generated. The court held that the trial court abused its discretion in even considering plaintiff's public interest representation and remanded with instructions to ignore nonprofit status of plaintiff's counsel. The court required plaintiff to file a tort claim as a condition precedent to bringing the suit. Trials court elimination of some damages was appropriate. The court adopted the federal rule that allowed for more liberal recovery of costs by the prevailing party in the civil litigation. So let's get into more of how this kind of all started. Let's see here. So in the case, it talks about, it goes in to talk about the stats of the case and just how much of funding was not given to the women's versus the men's athletics. So it states that that the football team generated over half of the income for the men's side of things on the sports side, which was about $1.5 million. So and so $3 million was the total funding available to the men's teams, whereas the women's program was roughly only about not even $700,000. It was only roughly 23% of what the men's was. The funds for the men's program were derived largely from revenues, both gate admissions and media rights, conference revenues, and guarantees. Most of these revenues are again derived from the football team. The women's team, on the other hand, the funding available to women's program was mostly derived from legislative appropriations, which wasn't even $500,000. It was $451,000, and very little came from gate admissions, which is only $10,000. They also state the plaintiffs in the years to come, opportunities for men increased by 115 positions, whereas for women it only increased by 9. And in that same time frame, that the scholarships that the men had available went from $380,000 to $478,000, where in the budget for the women's was only $150,000. So that would definitely make recruiting harder, definitely for the female coaches. Let's see here. The court ended up reversing and held that the football team should not have been excluded from the calculations, and the attorney fee should not have been reduced because plaintiff female athletes and their coaches and attorneys were public interest attorneys. The court affirmed and held that each sport respondent university would be allowed to keep the revenue it generated, and plaintiff was required to bring a tort action prior to filing the discrimination claim. So, as athletic directors and administrators, what can we do to make sure that our women athletes are getting the same, just all the programs in general are getting the same attention and the same opportunities as everybody else? We can make sure that the funding is the same and accurate for each sport team. You can't just give more funds to one team, boys or girls, and then not do the same for the others. It can't be different. You hear things such as, well, we're going to provide a sport team more funds this year because we expect them to have a really good year. That cannot be the case unless you are going to increase the funds for everybody. You can have a committee, as the athletic director, with the booster clubs and with the coaches to talk about these funding, and then we can, also make sure that we're promoting and all of the sports programs equal, and that we're providing the same opportunity, for all of our athletes. I want to in general, kind of just give you another overbrief of the case. So in 1980-81, the men's athletic program at Washington State University received over $3 million in funding. The football generated $1.43 million alone, and the women's athletic program at Washington State University only generated about $690,000. The majority, which came from legislative appropriations. Only $11,000 was earned from gate admissions. The plaintiffs, female athletes, and the coaches of Washington State brought suit against the institution, claiming that its distribution of athletic opportunities and resources violated the Washington State Equal Rights Amendment, and that the state's law against discrimination. Nothing noting that Washington State University had engaged in unlawful sex discrimination, the trial court entered an injunction require the women's athletic program receive 37.5% of Washington State University's financial support given to intercollegiate athletics during the 82-83 year. Further, the minimum percentage for women was required to increase by 2% each year until it recovered the percentage of women's undergraduates, which was 44%. I think I already covered that. The court did note, however, that the level of support for women's athletic was not required to exceed by more than 3% than the actual participation rate of women competing in sports. Excluding the football program from the comparison, the trial judge also excluded the football program when he appointed the funding for athletic scholarships when he ordered Washington State University to increase opportunities for women in athletics until the same level commensurate with the proportion of the female undergraduate students. Blair appealed, and the coaches and the women at Washington State that played sports appealed that portion of the trial's court opinion, which excluded the football program from the calculations for participation opportunities, scholarships, and distributions of funds. In the proportion of the injection, including from the Division of University Financial Support, the revenue generated by any specific sports program. So again, in conclusion, after they appealed that, the court reversed and held that football should not have been excluded from the calculations. So again, it's just a good reminder for us administrators to make sure that we are doing our part to make sure that everything is done equal and all our student athletes have the same equal rights and opportunities as everybody. Thank you.